Okay, welcome back, class number 5. Any questions so far? Any in your minds? No? All right. John, attendance? I had one semester I had a policy which I stopped enforcing. It was impossible to enforce. Is if you weren't in your seat by 5:20, you were absent. And the problem is I could never enforce it effectively because people would always be coming in, they're running in, running out, to be 1 minute late, and so I've relaxed that policy. But I did it one semester. It was more work for me than it was worth. But I do notice people are late. Okay. Let's start with this question, which I think you should all get based on your performance last class. But let's start a poll to recap last class. So in Wickard versus Filburn, the Supreme Court upheld the regulations under the Agricultural Adjustment Act solely on the basis of the Commerce Clause. Okay. 1, 2, 4. Oh, we only have 4. Okay. Let's see. Bingo. Nailed it. That's right. The answer here is false. And the reason why, I think you'll appreciate, is Justice Jackson's opinion was also premised on the Necessary and Proper Clause. And this question was designed to reinforce the idea that it's not enough to ask whether there's some sort of economic activity or whether economic activity has a substantial effect on interstate commerce. All those sorts of inquiries are premised on the Necessary and Proper Clause. Now, your reading today complicates that further. You read Lopez. Justice Rehnquist does not mention the Necessary and Proper Clause. Not once. Okay, please try to get here on time, please. Thank you. Justice Rehnquist doesn't even mention the Necessary and Proper Clause. But you know it's always lurking in the background. Okay? All right, so any questions on Lopez or Morrison or anything like that? I'm sorry, about Wickard, so from last class. We'll do Lopez and Morrison in a few minutes. Okay. Let's start today's lecture with a little bit of a detour. The first case doesn't actually fit in with what we've been talking about. I don't know where to fit it in. Randy and I talk about this all the time. There's no good place to put it. It's an important case, and we have to do it basically now because the next class we do Obamacare, which relies on the spending clause. So there's really no good place to put it. I put it here. And the first case involves the spending clause. But let's take a step back, right? I just said this case involves a spending clause. Does a Constitution actually have a spending clause? And this is a perpetual riddle of people who study constitutional law, right? Article 1, Section 8 lists all these powers that Congress has, but it doesn't list a specific power over how to spend the money, right? They can establish postal roads, they can declare war, they can punish the pirates, all these things. But the most basic function of what government actually does, which is spending money, it's silent on. Where do we start then? We start with Article 1, Section 8, Clause 1, right? The very first provision. And we've read this one before. And it says, the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. The other part doesn't matter, right? It's about uniform taxes. We'll maybe get that in the next class. But the first part is what I want to focus on, right? Congress shall have the power to lay and collect taxes, duties, imposts, and excises, right? So we know why that's important. Under the Articles of Confederation, the central government could not tax. They could only request money from the states, but they couldn't actually tax people directly. Congress is different. They can lay and collect taxes, duties, imposts, and excises. Okay, now tax was not like an income tax we think of it today. Taxes was generally either a duty, like when you buy a thing of alcohol, right? There's a duty imposed if you go to the airport, like duty free. And taxes were actually these sorts of taxes that were not based on population, not based on income, but based on population. They had to be uniform throughout the United States. So bigger states had to pay more taxes, smaller states had to pay less taxes. Basically, the tax was assessed based on how many people were in your state. This goes back to the 3/5 compromise, right? So representation and taxation. We don't actually have direct taxes anymore. We don't, because we have an income tax instead. But we know that Congress can tax. Okay. If Congress can tax, that means Congress has money. And when you have money, what do you do with it? You got to spend it, right? You got to do something to spend it. And the Constitution doesn't really tell us exactly how that spending works. It only says that they can pay the debts. Okay, so they can pay off debts, that's easy. And provide for the common defense and general welfare of the United States. What exactly does that even mean? Provide for the common defense and general welfare of the United States. Okay. Very early on in our republic, there was a debate, right? A constitutional debate. We already talked about one such debate, which involved the bank. You might recall that James Madison and Thomas Jefferson said, no, you can't do the bank. And Alexander Hamilton and later John Marshall said, yes, you can do the bank, right? So even in the earliest years of the republic, people who were instrumental in the ratification of the Constitution disagreed over really, really important questions, right? The ink on the Constitution wasn't even dry yet, and they were already debating how this document should be enforced. So we had another debate. What can Congress spend money on? Hamilton, as he usually did, took a very broad position, right? Hamilton said that Congress can spend money on basically anything necessary to provide for the common defense and the general welfare, right? He looked at this language in the spending clause as basically the purpose of federal spending, right? If some money can promote the general welfare, they can do it. If some money can provide the common defense, they can do it. Now, here's the critical question, right? Congress cannot regulate local activity, right? We know that. But Congress can then spend money on local activity. What you see here with the Hamiltonian vision is that the spending power and the taxing power is more broad than the power to regulate commerce, for example, right? That they can spend money on stuff that affects local problems, even though they could not regulate how the local problem itself is handled, right? By using this, it's effectively saying you can spend money whatever you want. You can't regulate any activity you want, but you can spend money to get states to maybe do what you want, which is where Dole is. That was Hamilton, right? There was a second side of the debate, which was James Madison, right? And as usual at the time, Madison took the more narrow view. He argued that there was limits imposed on the spending power, specifically the necessary and proper clause, right? Madison said that Congress could only spend money as a means to execute its other powers, right? That if Congress can establish postal roads, then they can spend money on horses and wagons and stuff like that. Right? If Congress can establish inferior courts, they can hire builders to build the courts and to staff employees in the court, right? That it was actually the necessary and proper clause that provided the authority to spend money. It wasn't a spending clause. It was actually the necessary and proper clause that we can spend money as a means to establish postal roads. But there's a catch, right? If Congress lacked the power to do X, they didn't have the enumerated power to do X, then Madison would say they can't spend money on X, right? If Congress lacks the power to establish the bank, then they can't spend money on the bank, which is obvious. If you can't establish a bank, you can't spend money on it. If Congress can't regulate local activity, then they can't spend money on regulating local activity, right? Madison argued that if we go with the Hamilton route, there's no limit on what Congress can spend money on. And if you can spend money on something, you can control it, which they recognize very well. So yeah, again, you have the Hamiltonian vision on one hand, which was a broad spending power. And then you have the Madisonian reading, on the other hand, which was a very narrow spending power. Who won? Once again, it was Hamilton. In almost every dispute, not all of them, but most of them, in almost every dispute between the Hamiltonian vision and the Madisonian vision, Alexander Hamilton prevailed. Now, it helped that John Marshall was at the helm and was guiding the country towards a broader view. But in every case, Hamilton favored generally the position that grants more power to the central government. And Hamilton usually prevailed. Not always, but almost always. Right? And the Supreme Court sometime later adopted the Hamiltonian vision. But they still recognized Madison's concerns, right? They said, if Congress can spend money on whatever they want, then they can control activity that's local, and we can't have that. So there's still some limits on how Congress can spend money. But as a general matter, the General Welfare Clause is the sort of the scope or the purpose, if you will, of what the spending power concerns. Okay. Questions on the Hamilton-Madison debate? Okay. All right, Lindsay, let's start with you, please. Why might it be problematic when the federal government is giving money to the states? Why might that be a problem as a general matter?
If the federal government is giving money to the states, they can control what the states are doing or regulate what the states are doing.
So generally, not just in government, but when someone gives you something, why are they giving you something?
To get something in return.
Yeah, there's no free lunch. I think you are all mature enough to recognize that if someone offers you something for free, it's not for free. Maybe if your mom, your grandma, whatever, no. But generally, if people offer you something for free, they want something in return, right? We are rationally self-interested human beings. There's nothing wrong with that. We give to get. Okay, that's your cynicism of the day. Even altruism, right? Even giving charity. Why do people give charity? Makes them feel good, right? They get a satisfaction from helping people. That's why they're charitable. So you still have a sense of utility, a sense of gain. Congress is no different, right? And let's just take the facts of the first case, for example, as an example, right? So Chelsea, what did Congress try to do with the drinking age, right? What did Congress try to do here?
So Congress wanted South Dakota to...
Not just South Dakota.
Well,
all states, right?
To put the drinking age at age 21.
Okay.
And they would lower funding for the highways.
Okay, very good. Thank you, Chelsea. Okay, so here we have a situation, right? This was the 80s. Some of you maybe were alive then, maybe not. I don't know. I love those looks. Drunk driving was a huge concern. Today, it's actually remarkable how much drunk driving has decreased. It's a stunning change culturally. Back in the 70s and 80s, driving buzz was was no big deal. It was not the same sort of stigma you have today. A lot of jurisdictions say we'll take your car away if you're driving drunk, and so it could be a felony. I mean, thank God for Uber. I think that's one of the greatest drivers of decreasing drunk driving. But it was very common. And some states had raised their drinking age from 18 to 21. Indeed, if you remember during the Kavanaugh hearings, Judge Kavanaugh said he loved beer. And at the time in Maryland, or was it D.C., the drinking age was 18 at the time. I can't remember if it was D.C. or Maryland, but it was one of them. He made a point of saying that during his hearing. So I thought Dole. Oh, God. When I was making the video for this, I almost wanted to play a prank on Randy and just put a clip of Kavanaugh saying, "I like beer." But I decided against it because he would murder me. Yeah, I know there are a lot of memes. Like I thought about it, I was like, but no, it's just too much. Like, I like beer. Like, no, there's where there's like the glass with like the beer in it. I was like, put a Kavanaugh meme in there. No. But there was a huge movement, right, to raise the drinking age. Now, Audrey, could Congress have ordered South Dakota to raise your drinking age?
No.
Why not?
Because that's not one of their powers.
Ah, very good answer, right? Congress does not have the power to issue directions or orders to states to enact laws, right? We'll study this in the next, I think, actually after the weekend, so you haven't gotten there yet, maybe. But there are a line of cases that says Congress cannot commandeer or order, like commander, right? Commandeer states to take actions. They can't do it, right? Congress can't tell a state legislature how to vote for bills. They can't tell a governor to sign a bill. They can't do those things. Okay, fine. So what does Congress do instead, right? They say, you know, state, we're giving you this money for highways, right? We've been giving this money for highways for some years. It's not a lot of money, but it's a good sum of money. You probably like that highway money, right? You depend on it, right? If you're getting this money from the feds, that means you're not taxing your own people for it. You don't have to ask your own voters to approve a new bond to fund these highways. You like this money, don't you? You want to keep it? Okay. Here's what you got to do. I'll make you an offer you can't refuse. And that's how federal appropriation law works. Congress often will entice states by giving them money with no strings, and then at some point they decide to maybe add some strings, or maybe they'll say, we have this new money coming up, and if you want some of it, you have to play ball. So it's a question of, can Congress then put strings on the federal money? Now Tyler, as a basic matter, do states have any constitutional right to receive federal money? They have some sort of they have to do it?
No.
So why can't the state just turn down the money and do whatever the hell they want?
They could. They could turn down.
So why are we in court? Why is not the answer to the first case South Dakota? If you don't want the money, too damn bad. Decline it. And then you can keep your drinking age at 18 or 15, whatever you want. Why is that not the answer? Well, it's simple. You don't want the money, don't take it, right? You don't want the free lunch, don't take the free lunch.
They wanted it, they just didn't want the strings.
Oh, I know. That's my question, right? But then why is not the answer, Tyler, to South Dakota, look, you can't have it both ways. If you want the money, take the strings. And if you don't want the strings, use your own money to pun your own roads, right? You can have your own whatever high drinking age you want. Why is that not the answer?
Because the government still has the ability to attach some strings and require some action as it affects the larger government initiatives, such as, in this case, if it's necessary that we support this minimum drinking age act, and this is the way that we're going to do it, this is how the...
Yeah, I think you got it more or less right. Let me try to rephrase it a little bit, right? The question is not whether South Dakota can decline the money as a means to avoid this problem. The question is whether Congress can put the string out in the first place. If that makes sense, right? Of course, South Dakota can decline the money. Maybe they will, maybe they won't, I don't know. But the question presented here is whether Congress can impose the string in the first place, right? South Dakota is not challenging their own decision to accept the funds. South Dakota is challenging the act of Congress that conditioned the funds on these payments.
So they can, but only to a certain extent, that it's not, that the pressure, I think that's one of the limitations.
Well, yeah, exactly. It's one of the limitations, exactly.
One of the limitations, so the pressure cannot force the state into compulsion.
That's one of the reasons why, but we'll get there in a couple minutes, I promise. We'll get there. You're right on track. But I want to focus on this point first. South Dakota is challenging that the state can't put these strings on this money, okay? Now, Fabian, I'll ask you this question, right? Why can't Congress put these strings on this money? What provision of the Constitution is being violated here? Right? If South Dakota is saying you can't put these conditions on this money, what provision of the Constitution is Congress violating? You always have to give me... I'm looking at it right here. Couldn't we say that general welfare, highway safety, isn't that Hamiltonian? Isn't that a broad reading of... Isn't spending money on highway safety within the scope of the spending clause, the Hamiltonian reading?
Well, it's not enumerated, so it would be an implied power according to this approach.
And where do we get implied powers from?
The necessary and proper clause.
And who said the necessary and proper clause is relevant to the spending?
Hamilton? Madison.
Bingo. Here is another case where the court is ruling based on the necessary and proper clause, and they don't even mention it. Faven walked right into it. She saw right through it. They were doing very good, right? She saw right through what Rehnquist was getting at, right? The court accepted the Hamiltonian reading of the spending clause. Without a question, highway safety, drunk driving, general welfare, easy, easy, easy. But the question is it both necessary and proper for Congress to put this string on the federal funds? And here's something that's also not being said here, right? So far, we've only talked about necessary, right? We said necessary means convenient, right? Is it convenient to Congress to put this string on the money as a means to raise the drinking age? Yeah, I think under McCulloch, definitely under McCulloch, I think it's necessary. But there are two words there, right? It's not only what is necessary. You have to ask, what is proper? And here we're starting to see the court get at something, which they don't say. You'll see in the reading, I think, for next week a little bit more clearly. Scalia finally gets to it in the 90s. But what the court's basically saying here is that some strings attached to funds are not proper exercises of federal power, right? That some kind of coercive, right? Favorite coercive, right? Some kinds of coercive spending conditions are not proper exercises of federal power. You will not find those words anywhere in the opinion, neither in Rehnquist or O'Connor. But what they're effectively saying is these are not proper exercises of federal power. Why? Because they intrude onto state sovereignty, that they put the states in too difficult of a position. There's no express clause of the Constitution that bars this. It's an implied, right? It's saying we don't think it's a proper way for Congress to act, and that's why they can't do it. The answer is not the 10th Amendment, and so many judges piss me off when they say this, right? They say, oh, the spending clause violates the 10th Amendment. No, the 10th Amendment doesn't actually give you the rule of decision. It's a necessary and proper clause. So many judges make the mistake, it's scary, right? They actually don't understand because it doesn't really matter to them. But it's actually the necessary and proper clause, right, that the court's relying on here to say this is not a proper exercise of federal power, that they can't impose this sort of condition on how money is spent. Now, how do you know it's not proper? Rehnquist gives us 4 or maybe 5-factor test. Where does he get it from? Well, they're kind of making it up, right? Once we get to this 4 or 5-factor test, we've sort of just dived off the textual deep end, right? At that point, I can't help you, right? Why he picked those 4 or 5 factors, I don't know. I mean, I know, but it's not based on the actual principle of law. It's sort of just cobbling stuff together. But the reason why you get that 5-factor test is because of necessary and proper clause, right? In other words, if some spending violates those 4 or 5 factors, then it's not a proper exercise of federal power. That's what the Dole test is actually inquiring about. Does this spending condition violate the necessary and proper clause? That's what they're asking, right? Okay, that was a bit of a long lecture, but I think I got everything out. Does everyone, that make sense, everyone? Again, I didn't actually understand this point until about a year ago, which is scary. I feel inadequate. But when Randy and I were writing the chapter for this book, like I finally beat it out. It's like, oh yeah, duh, necessary and proper. Then sort of hit me. And we sort of hinted at that in the video. It's a hard concept to get at, but I think between now and the PDFs, you can get a good sense. Yeah, Audrey.
Why is it not the 10th Amendment again?
The 10th Amendment doesn't say anything, right? I don't have it up here. The 10th Amendment might be a reason why it's not proper, right? But the 10th Amendment merely recognizes a basic principle, that whatever power Congress lacks belongs to the states. So it's merely circular, right? The 10th Amendment doesn't get you anywhere. But it recognizes that it's improper for the states to have this sort of condition put upon them, right? Think about it. Puts a state in a tough spot, right? The Congress says, oh yeah, we'll give you this money, but you have to do something we can't otherwise make you do. And what the court's saying is, if it's too coercive, you can't put the states to that choice. It's an unfair choice. And let me give you an example, right? You'll do the reading for tomorrow with the Obamacare case, right? A state is given a choice. You can either expand the number of people on Medicaid, or it will take away like billions of dollars. And for most states, it would bankrupt them. They couldn't afford it, right? They just couldn't afford it. So Chief Justice Roberts describes like this. It's like putting a gun to your head and saying your money or your life. What do you choose? You give them money, right? You don't have a choice. No one's going to say, oh yeah, kill me, right? No one's going to take the other option, your money or your life. And so what the court's getting is it's not proper to put the state to these sorts of choices. And that's the basis of Dole in the spending power analysis. We'll get to the 4 or 5 factor test in a minute. All that stuff I think is just made up. It's gobbledygook, right? But the basic premise of why we even have that test, right? Why can't the court just say, do whatever you want, right? Congress, put whatever strings you want. We don't care. If it's your money, who are we to tell you to spend your money? General welfare, that's it. The court could have just said the only limit is if it's in the general welfare. If it is, then we don't care. But they go and put this 4 or 5 factor test there, which exists. Because they're deciding, is this actually a proper exercise of federal power? Okay. Makes sense? Okay. So let's actually walk through the 4, and I keep saying 4 or 5 factors quite deliberately, because Randy and I can't agree if it's 4 or 5, but I think the book says 5. Whatever. It's 4 or 5 is close enough. Okay, so I think Lindsay, you're next. Walk me through the elements or the factors that Chief Justice Rehnquist identifies for when a spending condition becomes unconstitutional.
Okay, so the first factor is the spending has to be pursuant to the general welfare.
Okay, and that's Hamilton, right? That's Hamilton. Basically, the first factor is a gimme. It's automatic. Everything is in the general welfare, right? Even like spending money to benefit like one specific constituency is in the general welfare. So basically, the first factor is, meaningless. It's automatic. Okay, what's number 2?
The conditions given for the spending must be unambiguous.
Okay, this is actually important. You'll see a lot in law what's called the clear statement rule, right? That if you want, even in contracts, right? If you're signing a contract and the terms are ambiguous, the party might not be bound by them, right? This is a general principle of contracts or constitutional law. If you want to put a string on federal money, it has to be clear. It cannot be ambiguous. It's not like, well, if we give you this money, maybe you'll pay, maybe you won't. No. It's got to be, we give you X dollars, you do Y, period. This is an easy one, and I think it's actually a matter of due process, right? You can't create a law that people don't even know what's expected of them, that the due process law requires a clear statement of the law, right? There's the, was it Nero? It was one of the famous Roman emperors, I think it was Nero, maybe Caligula, who would put all the laws on top of these very tall columns. You couldn't see them. They were up there, right? So the law was published, but they were so high up in these columns, no one could read them. We don't have that. You have to have a knowledge of what the law is, right? We know ignorance of the law is no excuse, but a corollary of that principle is you have to know what the law is. It can't be hidden. It can't be ambiguous. So the second principle, I think, is a matter of due process. All right. Go for number 3, Lindsay. Just finish them up.
The spending has to relate to the federal interest for the reason for the spending.
Okay, this one's the key, right? And this is really, I think, where the entire case turns. I'll mention number 4 briefly, but I'll come back to it. Number 4 asks whether there's some other provision in the Constitution that prevents it. This is like, duh, right? If the money says, we are giving you money if you shut down all the newspapers in your state, well, come on, that violates the First Amendment, right? It's an obvious thing, right? If the money condition actually violates another amendment, well, then of course it's unconstitutional. So really, of these 4 factors, the only one that actually matters is number 3. And Rehnquist says that there has to be, that the condition imposed is related to a congressional power. Okay? Here, I think, is the biggest difference between Justice O'Connor and Justice Rehnquist. Right? So, Chelsea, what's the relationship between highway funds and the drinking age?
He said that if you're under the age of 21,
Yeah.
You'll drive to a state that you can drink in legally, and
Right.
it'll promote drink driving across state lines. So then it becomes an interest of safe travel.
Okay, very good. So here is, right, here is the government's argument, right, which the court more or less adopts. Let's say that South Dakota has a drinking age of 18 and North Dakota has a drinking age of 21. That because of this discrepancy, there's not a uniform standard nationwide. All of these minors will drive across state lines to buy alcohol, and once they buy it, they then will drive back to their home state drunk and increase road safety. Okay. Chelsea, does that relationship make sense?
Yeah.
Is it a close or a tight fit? Think of the means and scrutiny we keep talking about, right? If you're trying to ban highway safety, if you're trying to increase highway safety, right, is raising the drinking age a good fit or a good way to do this?
I go back and forth because I think there's other things that can be done to promote.
Yeah, what does O'Connor say? Just finish this up.
That I know she says like how many drivers are actually under the age of 21 driving under that, and then what exactly is the connection between drunk driving?
Okay, very good. So this is the $1 million question, right? This is where O'Connor and Rehnquist divide. By the way, fun fact about Justice O'Connor and Rehnquist, if you watch my video, you know this already, but I won't spoil it. They went to law school together. They were at Stanford at the same time. He graduated, I think, first in the class, and he went to go on to clerk for the U.S. Supreme Court. I think she graduated number 3, and she could not get a job. At the time, the legal market for women was non-existent. Law firms would say, we'll hire you as a secretary. And she graduated 3rd in her class at Stanford Law School. Now, here's the part which we all knew. It was always known that they dated in law school. But it isn't known how much they dated. This only came out last year in a new book. Apparently, they went on 30 dates in 30 days or something. They basically went out almost every day for a month. It was insane. He was courting her. And then while he was clerking in Washington, D.C., he wrote her a letter in which he proposed marriage. She turned his ass down. So the future Chief Justice of the United States got turned down by the future Associate Justice of the United States. And they served in the court together for almost 20 years. It's a great story. It's a wonderful story. Eventually, O'Connor got married to a really wonderful guy, and I think Rehnquist also got married, so I guess things worked out. But you know, they dated for some time while they were in law school. There's one other anecdote which I won't cover in this class. It's the First Amendment case. In the 1990s, I think it was in '96, the court had a case about internet pornography. And at the time, the justice didn't really even know what internet porn was. So Justice O'Connor asked the librarian to wheel a computer into her chambers and to demonstrate how easy it was to obtain internet pornography. So here's the scene. You have Rehnquist and O'Connor in the same room at the U.S. Supreme Court watching internet porn together. And apparently O'Connor's only comment was, "Oh my." And I know this because actually Ted Cruz was clerking that term, and he put this in his biography. So that's where I got this anecdote from. I was like, oh my God, this is such a good story. What?
They should make a movie.
No, they shouldn't. I will not watch that movie. No, thank you. But anyway, it's a great story of O'Connor and Rehnquist. And they were both appointed by Republican presidents. In fact, apparently, Rehnquist put the bug in Reagan's ear to nominate O'Connor for the Supreme Court, although, you know, a lot of other people. But Reagan ran the promise of putting women in the Supreme Court, and he picked Sandra Day O'Connor, who at the time was an appellate court judge in Arizona. Very fascinating story. I mean, you know, you forget these are human beings who have stories. Can you imagine how awkward it is? Like the guy who you turned down for marriage becomes basically your boss is the wrong word, but like your chief. That's gotta be kind of like awkward, right? Just like a little bit, right? I guess they got over it, right? You know, it's.
They're both so successful, though. It could have been.
if you read his proposal letter, it was pretty creepy. It was like we've been dating for a while. I think it's the next step for us, like that sort of thing. I mean, I don't know if actually the letter itself I've seen, but I've seen discussions of it. It's basically like, it's time. Let's move on. It's the next step. Let's take the next step. All right. Not like I love you, or you make me happy. It's all right. Let's by letter, getting proposed by text. I don't know how that would even work. No, and I think he may have even written on Supreme Court stationery, which is kind of a douchebag move. I think. I'm sorry. I think it's kind of, yeah. You agree? Yeah. I might be wrong about that, but I'm pretty sure he wrote it from the Supreme Court on stationery. It's like rolling up with a Porsche nowadays. Anyway, going back to the actual case. O'Connor says that raising the drinking age was not related or germane, not German, germane to the expenditure of highway funds, right? Think of it this way, right? If Congress was worried about drunk driving, Tyler, if Congress was worried about drunk driving, what's a more specific way they could target drunk driving rather than highway funds? If they're concerned with drunk driving, how could they actually target that problem more directly?
Via the overarching intent of the act, if it's both necessary and proper to have a nationwide regulation.
No. If Congress was actually concerned about drunk driving, how could they spend their money more efficiently rather than withdrawing highway funds? Right? Because if you withdraw highway funds, you're making the roads less safe. Right? The roads are now bumpier. People might get into more accidents. They might veer off the side of the road. I don't see how holding back highway funds reduces drunk driving. If they were actually concerned about drunk driving, how would they be spending their money, Tyler?
Maybe via agency regulation. Maybe something more local, like HASS or CMS or something like that.
And what would that money do? Give me lots of acronyms. What would that money do?
Develop lower level policy and procedure.
To do?
Education.
About? Good. Actually do something to stop drunk driving, right? Maybe spend money to hire more state troopers to police for erratic driving, right? Maybe have an education campaign. I like that idea, right? To encourage people to not drink and drive, right? Maybe you raise funding for those highway, what do you call them, like the where they stop a lot of people. Thank you. Yeah, checkpoints, right? You've seen those in the road, like where they basically check everyone going through an entire town. There are lots of ways that Congress could actually improve or eliminate drunk driving, but what they're doing now is kind of a jerk move. They're holding back highway funds to make the roads less safe. And O'Connor makes this point I think she makes it a little bit indirectly, right? She says the federal government can mandate how the money should be spent, right? In other words, we'll tell you how the money can be spent. We'll say if you want the highway funds, you have to use this type of asphalt, you have to use this type of paint, right? You have to have roads of a certain width, right? You need to have dividers, you need to have lights, you have the little reflectors, right? O'Connor says the condition has to actually relate to the spending of the money. Right? The condition has to relate to how the money is being spent. Here, use this type of asphalt, right? You have to have certain width, you have to put yellow bright lines, you have to have street lights, etc. But here, O'Connor says, the condition has nothing to do with how the money is being spent. Right? The conditions on drinking age, the money being spent on highway safety, on roads. Where is the connection? So O'Connor would require a very close fit between the means and the ends. If your end is to reduce drunk driving, the mean you choose has to actually relate to drunk driving. For example, education or highway checkpoints. But here, what's the mean? Holding back construction funds. And what's the end? Reducing drunk driving. Is that a close fit? No. For the dissent, the fit is not close enough. However, for the majority, it's deferential. They say it's a close enough fit for us, right? It doesn't have to be exact. It's good enough for us. There's some general relationship between spending highway funds and road safety. Good enough for us. It involves cars, right? Basically, that's a connection. Highway funds and drunk driving, they both involve cars and roads. Genius, right? That's it. But Justice Rehnquist, for the majority, is not willing to second guess the fitness or the germaneness. It's related enough for him. So as we discuss sort of means and scrutiny, we ask how close must the means be to the ends? O'Connor would require a very close fit, whereas the majority would require a much more, or would allow a much more attenuated or tangential relationship. Okay. So everyone get the first 4 factors, of which only number 3 actually matters. You'll find this a lot where the Supreme Court has like a 5-factor test, and only one of them actually matters. It's not like torts, right, or contracts for 5-factor tests. You actually need all 5 factors. Usually 3 of them are gimmies or automatic, and that's why I hate multi-factor tests. It's just, okay, give me the 1 factor, and then we'll move on. Like there's some cases where there's like a 17-factor test, at which point it's irrelevant. You have that many factors, you're not actually balancing. Law, it's completely arbitrary. Okay. So any questions? The first 4 factors. All right, Fabian, oh, perfect, you're next. You mentioned the 5th one a few minutes ago. Randy thinks it's the 5th one. I'm not really sure where to put it, but I'll just go with Randy's thing. What's this other factor that the court identifies in Dole?
Oh, so the 5th one here is Rehnquist is saying that the financial inducement offered by Congress, it becomes unconstitutional if it's so coercive that the pressure turns into compulsion.
Okay, what does that mean in your own words? Like, what's he getting at there?
Pretty much he's saying, like, Congress can't withhold money to twist a state's arm to, like, get them to do something that Congress wants.
Okay, very good. Again, this is a necessary and proper analysis, right? What Rehnquist is basically saying, he doesn't say this, but what he's basically getting at is when the condition is too severe, right? When a state is at risk of losing so much money, the state lacks a meaningful choice. Right? Think of the Obamacare example I gave you a few minutes ago, that a state can't meaningfully say no. And we know under the law of duress, right? If you actually can't say no to an offer, then it's an invalid contract. It's basically a constitutional duress doctrine, if you want to think about it, right? That the conditions are so severe, so extravagant, that no state could reasonably say no, that it's not a valid law at all. It's not a proper means of exercising federal power. And as a result, if it gets to this point, then the condition itself is invalid. Here, that wasn't a problem. The state would lose, 5% of highway safety funds. So we're talking about a few $1 million, right? It's gonna be annoying to lose it, but it's not going to break the bank. But if it gets to a certain point, you have that problem. Between Dole and the Obamacare case in 2012, the court didn't identify any spending condition that violated this rule. The Obamacare was the first law that actually did. Like when I went to law school, we always said, yep, this rule from South Dakota v. Dole exists, but it'll probably never be violated. And the first court to find this was actually the Supreme Court in the NFIB case. Okay. Yeah, Audrey.
Something just popped in my head that I remembered. Is there a case about Louisiana and their gambling in the roads, like with highways?
Okay, a Supreme Court case?
I don't know. Never mind. Because I just remember, I think I learned something about why they weren't going to be funded for their roads, but they had to, because they were gambling or something like that.
I am not sure, but if you want to look it up later and ask me that, I'd be happy to answer it
I'll
later.
look it
I'm not sure what you're asking. I'm sorry. Yeah, Fabian.
So, I guess at the end of this case, pretty much the point is the Congress can't strong arm states
Yes.
into changing their laws. So, but there are other ways that you go about it, like education was the example. So I guess like I'm always trying to think like, what's the like line of delineation that like Congress has effects on, can do something differently to affect a state? Because it's like you can't use money.
Well, under the majority opinion in Rehnquist, you don't have to have a very tight fit, right? Rehnquist basically said so long as the money has a general relationship to what you're spending on, it's okay. O'Connor's dissent would require a much closer fit, but the majority do whatever you want. So as a result of the of the 4 factors, it's hard to violate those 4 factors. At this point, with respect to the spending clause, the 5th factor, the coercion, is really the only factor that matters. Now, number 2, the clear statement rule, that one's actually litigated a lot, right? But so long as Congress makes the condition clear, they're out of the woods, right? So long as it's clearly stated. So really, of these 5 factors, as long as Congress states the condition clearly, factor 5 is the only one that matters, right? Factor 3 is not going to play much of a role. Factor 4 is kind of irrelevant because they can't do it anyway if it's unconstitutional. So everything then turns on the coercion. And the court has only once found something crosses that line, which was the Obamacare case, which you'll read for class thing tomorrow. Okay. All right. So again, you have to know the 4-factor test with the 5th factor, but for your own knowledge, the only one that really matters is the coercion factor. Because of the way Chief Justice Rehnquist drew up the 3rd factor, it doesn't have much teeth. And when I say it doesn't have much teeth, I'm effectively saying is it doesn't have much of an enforcement, right? The courts will be deferential to the process. Okay. All right. Any other questions on South Dakota v. Dole? A funny story. Randy said he recently met Elizabeth Dole, who was a Secretary of the Transportation, and she apparently had no idea about this case. We live in this bubble. I mean, she was Bob Dole's wife. Or she is Bob Dole's wife. You probably know him best from the Viagra commercials. He ran for president in '96, was a big deal, and his wife was the Secretary of Transportation. And then she was, I think, senator from North Carolina for, I think, a term or so. Okay. All right, let's move on to the next case, or the next cases. We go back to our friend, the Commerce Clause, or hello, darkness, my old friend. Yeah, it describes this class very accurately, especially the darkness part. We come to Lopez. Okay, was that a hand, Audrey? Was that a hand? Okay, you lifted.
I think I always just naturally do that.
It's okay. 1996, Lopez. Before we get, I'm sorry, 95, I was off by a year. Before we get to Lopez, I want to bridge the gap of what happened when we left off, right? The last case we had was decided by the Warren Court. We had Heart of Atlanta Motel, that was a segregated hotel, and we have Katz Vacuum McClung, that was the segregated restaurant. The court in the 1960s upheld the federal civil rights law. And they upheld it under a broad reading of the Commerce, Necessary, and Proper Clause. And the argument was this: even though the restaurant doesn't traffic in interstate travelers, their food that they serve traveled in interstate commerce, and therefore, because they're using interstate food, their act of segregating the local has a substantial effect in interstate commerce. Okay? Once you have that sort of ruling, right, that any sort of activity that has a jurisdictional hook, that is, an activity that has some sort of substantial effect in interstate commerce can be regulated, there's not much of a limit. But then we get to Lopez. And by Lopez, by the 1990s, the Supreme Court had not declared a law beyond Congress's enumerated powers in like 6 decades, right? Most law students were taught in law school that Congress can do whatever it wants, that following the Warren Court, the Supreme Court was no longer willing to tell the Congress no, that basically the necessary and proper power stretched as far as the democratic process would allow it to stretch. But fortunately, not everyone listened to that message. And I always make this point in class to students, but you should never take constitutional law as a fixed idea. Ideas change, and the Supreme Court's interpretation to these powers changed. I showed you that timeline in class the other day, We don't live in a fixed environment. So you should always be willing to second guess current doctrine. And I look here to Lopez as a good example. Who's next? Lindsay, you next? Are you related, by the way?
No.
Okay, totally. I just look at the roster and I tell you the same last name. I've had several students with the same last name who are not related. It happens quite a lot. Okay, so Lindsay, you want to give me the facts in Lopez?
Congress enacted the Gun-Free School Zone Act of 1990.
Good.
And Lopez was charged with carrying a handgun and bullets to Edison High School.
In San Antonio, yeah.
In San Antonio. The state charges were dismissed after the federal charges were filed under this act.
Let me just stop you right there for a second. Texas had laws in the books about carrying a gun to school, right? Why did Texas drop the charges when the feds came in? It's not an obvious answer, but why didn't Texas prosecute this Mr. Lopez for violating his own Texas laws?
The federal government was going to prosecute him, so it's cheaper.
Oh, that's the magic word, cheaper, right? The state police love when the feds come in. Why? The feds pay for the prosecution, and the feds pay for the incarceration when they lock him up, right? It's very common. The state police get all the glory for making this arrest, keeping schools safe, yada, 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 right? And the feds come and do all the hard work. So the state's police love when this happens, right? And in fact, they can actually prosecute him twice. They won't, but the double jeopardy clause, at least for the next few months, next few weeks, says you can be prosecuted twice by two different sovereigns, right? So you can be prosecuted for the same offense by the states and the feds. Double jeopardy does not attach. It's a debate about whether that's correct, but that's the current law. So the feds came in, right? Now, have you actually worked in a criminal defense firm or for criminal defense? You have?
I'm working for one right now.
Oh, very good. So, Lindsay, you'll tell me, what percentage of criminal cases actually ever go to a trial?
Like less than 2?
What happens in most criminal cases?
They plea out.
They take a plea bargain, right? And the reason why plea bargains are offered is a lot, right? So first, it eliminates the need for a trial, it saves time. But generally, these guys are guilty. I mean, I don't want to say that as a general rule, but more often than not, people being prosecuted actually did the thing. And when you take a plea bargain, you cooperate with the government and you get a reduced sentence, right? So the advantage of taking a plea is you probably spend less time in jail. Now, a lot of times people are coerced in taking pleas because their lawyers just don't have the time for it, it's expensive, and they say, look, even if you're innocent, you probably lose anyway. But here, Mr. Lopez's lawyer did not push him for a plea bargain. I actually looked at the guy, his name was Jack Carter, who was a federal defender in San Antonio. I emailed him almost 10 years ago. He never replied. He's probably retired. I don't even know. This was in 2010 I contacted him. But Mr. Carter decided not to take a plea bargain. He said, we're going to challenge the constitutionality of this law. Now, if you had asked virtually any law professor in the country who wasn't named Randy Barnett about this, they would have told you you're insane, right? That of course Congress can ban guns in school zones, right? Because education has a substantial effect on interstate commerce. If kids are worried about guns, they won't learn. If they can't learn, they'll do bad in the economy. Blah, you can do the syllogism, right? But he challenged it, and he told his client not to take a plea, knowing his client can get more money. I'm sorry, not more money, more jail time. And it worked, right? He took this case all the way to the U.S. Supreme Court, and the Supreme Court ruled that the Gun-Free School Zone Act was unconstitutional. Why? Okay, Chelsea. Why was the Gun-Free School Zone Act unconstitutional?
Because the act itself never listed anything about commerce.
Okay, so let's be precise. What was the act actually regulating? And when I say regulate, I mean prohibit, because we know prohibit and regulation can be the same thing, right?
Mm-hmm.
What exactly was the act regulating, Chelsea?
Guns in the school.
Guns in schools. Was it regulating the manufacture of guns?
No.
Was it regulating the transportation of guns across state lines?
No.
Was it regulating the parts used to make a gun?
No.
No. What exactly was it regulating?
Just the gun itself.
Okay. Now I'll ask you a question for you. But can't we say it like this, right? That maybe one person having a gun doesn't really have an effect on interstate commerce, But if thousands of students nationwide start packing heat in a school under the rule in Wickard, we aggregate it. Wouldn't those activities then have a substantial effect on interstate commerce? And in which case Congress can regulate it. Why is that not the answer here?
I think because that the act itself of regulating the activities didn't really play a role to meet the end of.
But again, if Farmer Filburn decides to keep his local wheat, and all the farmers keep their local wheat, when you aggregate those activities together,
And then I guess, yeah.
those activities would then have a substantial effect on interstate commerce. So then why is this case not governed by Wickard and the aggregation principle? Why can't you simply aggregate all these activities?
Is it about the channels?
No. We'll get to the channels in a minute. Tyler, why can't Congress aggregate all these local activities?
So Wickard was it was part of a commercial market. There's not a commercial market for individual possession.
How does Rehnquist, what's the magic word Rehnquist used to describe activities? There's a magic word.
Economic.
Bingo.
Figured it out
Both.
when I started talking.
Both got it. That's exactly right. Both are right. Rehnquist draws a line, and he says, in Wickard, when the court was talking about activities that can be aggregated, the court was only referring to economic activities. Economic activities. In other words, you can aggregate economic activities if they have a substantial effect on interstate commerce. However, the act that is being regulated here, Rehnquist says, is not economic. The act being regulated is the mere possession of a gun in a school. It's not the buying or the selling or manufacture, it's possession. And what the court says is the mere possession of an item is a local activity that is non-economic. All right, it's non-economic. And because the activity is non-economic, you cannot aggregate them. Right? You can only aggregate under Wickard economic activities. That makes sense to everyone. So Fabian, let me ask you a question. We were at Wickard yesterday. It feels like forever ago, but it was yesterday. It was yesterday, right? Yeah, it was yesterday. Does Justice Jackson in Wickard articulate this rule that you can only aggregate economic activities? Did he say that anywhere? Do you remember us talking about that yesterday?
Well, yes, within a state. I mean,
No, economic activities. Was that test actually in Wickard?
No.
No, it wasn't. So Fabian, where'd Rehnquist get this from? Where'd Rehnquist get this from?
This aggregation test?
No, the aggregation is from Wickard, but limiting the aggregation principle to economic activity. Where did he get that from? Yeah. Lindsay, where did Rehnquist get this from?
Wasn't it the opinions of the cases from the 1930s? They used the language in those cases to kind of.
But did Jackson actually limit his opinion to economic activity?
No, but there was, if I remember right, there was language in that opinion that alluded.
Oh, I like it. Right. So here's what Rehnquist does. Jackson never actually said economic activity, but the activity at issue in Wickard was economic. I said it again. Wickard didn't actually discuss economic activity, but the activity at issue in Wickard was economic in nature. Therefore, Rehnquist puts a limit on Wickard. It's not in the opinion. I think you said alluded to. That's a good word, right? It's alluded to. All right, everyone with me? So this is an important principle of law, right? It's an important principle of law wherein only economic activities can be aggregated. And merely possessing a gun is not an economic activity. Everyone get that? This was a significant change. Now, why did Rehnquist make this change? The Rehnquist court had I don't know what the right word for it is. It had a sort of a purpose or a mission, which is often called the New Federalism, where the court tried to put a limit on federal power. And they didn't overturn the New Deal precedents, let's be very clear. He did not reverse Wickard. He simply said, okay, Wickard said you can aggregate economic activity, that's it. We're not going any farther, right? Randy describes as this far but no farther. Whatever the New Deal court set is the outer boundary. We will not push 1 inch past that. Congress, you can aggregate together economic activities, but you cannot aggregate non-economic activities. Everyone get that? Make sense? All right, now Chelsea, let me ask you another question. Now, most guns are not manufactured in Texas. Maybe they are, I don't know. But presumably the gun maybe traveled in interstate commerce. Maybe the parts of the gun did, maybe the bullet did, right? Why can't Congress then regulate the gun that traveled interstate commerce? Think of the restaurant in Alabama, right? The restaurant itself was fixed, but it had food that was traveling interstate commerce. Why can't Congress then regulate the gun because the parts of the gun travel interstate commerce? Under the Katzenbach case.
Is it because it's limiting it to just school?
Well, but why can't Congress say, or let me ask the question differently, why can't Congress regulate a gun in a school zone because the gun itself traveled interstate commerce? How is that different than the restaurant case? What do we call that? Right? How do we describe, I gave it a phrase, a memorable phrase, something STD perhaps.
Oh, the herpes.
Yeah, there it is. Right? Why doesn't herpes theory apply to this gun? Yeah, Randy was right, it's memorable.
I'm trying to remember.
Audrey?
Was the herpes analogy, this is what I would say, was it the analogy more like, I was thinking the Atlanta cases, people were traveling,
No.
staying in the hotel.
Well, that's commerce, right? The people were the commerce. But in the restaurant case, the food traveled interstate commerce, therefore Congress will regulate it, right? Remember we called that a jurisdictional hook? Remember that phrase? So why can't you uphold the Gun-Free School Zone Act by saying that guns travel in interstate commerce? Why is that not the answer? There's an answer here. There's an answer here.
I mean, I have
Why is Rehnquist mad? What did Rehnquist say Congress did not do? Congress screwed up in one regard here.
I think that they could have rationally found that gun violence in school is a commercial problem by I feel like you could have argued it completely differently.
What did Congress not do? I think Chelsea had.
Yeah, they never said anything in the actual act about.
We call this the lazy drafter, right? Whoever drafted this bill got lazy. Had they included one sentence that says, whoever carries a gun that traveled interstate commerce in a school zone is guilty of a felony. This case turns out differently. Again, if they added one sentence to the bill, whoever carries a gun that traveled interstate commerce in a school zone commits a felony. Done. Indeed, Congress reenacted this very law while the case was pending. Congress enacted the exact same School Zone Act. It's on the books to this day. To this day, it's on the books. With the jurisdictional hook that the gun is to travel interstate commerce. Traveled in interstate commerce. 4 words. Had Congress added 4 words, this case would turn out differently. Because it doesn't matter that possessing a gun is not economic. Oh, it's double negatives. Let's try like this. If Congress adds this hook, it's irrelevant whether the activity is economic or not, right? If Congress adds this hook, it doesn't matter if the activity is economic. It only matters if the activity is economic if there's no hook. The lazy drafter didn't put those 4 words in there. As a result, the court wouldn't save the law, right? Rehnquist says you need to actually make findings of how the gun traveled in interstate commerce. And indeed, this gun almost certainly did travel but you need that in the statute, right? It's what's called a jurisdictional hook. The statute, the element of the statute must specify that the gun traveled in commerce. And then you have to prove to a jury that the gun traveled in commerce. And if you can prove to a jury the gun traveled in commerce, then the conviction is proper.
What if it was within, what if it was just within Texas?
You make one state within a gun entirely within one state.
Yeah, what if he bought the gun in Texas?
Well, where'd the metal come from?
Right.
Where'd the bullets come from? Where'd the wood come from? Where'd the plastic come from? Now, there was actually a movement some years ago in Montana where these guys wanted to make what they called Liberty guns, which were guns manufactured entirely in state. Okay? Now, this is bleeding over into the last case, Raich. Think of marijuana, right? That's cultivated and grown entirely in one state. Congress can still regulate it because the cultivation of marijuana was deemed economic. That was Stevens, right? Rehnquist said you can aggregate economic activities, and in Raich, the court came back and said cultivating marijuana, even if there's no money changing hands, is economic activity, which can be aggregated. And I think the court would say that making a gun, like cultivating marijuana under Raich, is economic activity. Okay, I think you guys got this. All right, so the crux of the Rehnquist analysis. First, you can only aggregate economic activities. You cannot aggregate non-economic activities. And second, Congress needs to add a jurisdictional hook, right? The court won't read it in for them, right? The court won't presume there's one there. Congress needs to actually have a hook about how the gun or whatever's being possessed traveled in interstate commerce. Okay? Go on with me. Rehnquist also has these three broad categories, which are not very helpful, but they help a little bit, right? The first is channels of commerce, and things of heart of Atlanta, which is like the highways and the roads, right? Things that are actually traveling across state lines. The second is what's called the instrumentalities of commerce, things in commerce. We give examples in the book of ports and railroads, but probably even the gun itself can be considered an instrumentality of commerce because it's being transferred across state lines. But the biggie is the third one, right? This is about activities. And when you see activities and substantial effects, it's been necessary and proper, right? Congress can regulate interstate activity as a necessary and proper means of regulating interstate commerce if the activity is economic in nature, right? And that's the key fact of whether it's economic. And Rehnquist says even Wickard involved economic activity in a way that possessing a gun in a school zone does not. He says the Gun-Free School Zone Act has nothing to do with commerce. It's not. Okay. All right, so any other questions on the Rehnquist majority? I want to flag one sentence. Rehnquist says that the Gun-Free School Zone Act is not an essential part of a larger regulation of economic activity, in which the regulatory scheme could be undercut unless the interstate activity were regulated. This was a very important sentence that plays a role in Raich later on. What Rehnquist is basically saying is that even if you have local activity that's non-economic, if the regulation of the activity is part of a broader federal program, which Congress can enact, then Congress can go after the local activity. It's an additional power under the Necessary and Proper Clause. In other words, for Congress to regulate, say, drugs nationwide, it may be necessary for them to regulate local cultivation of marijuana, even if that local cultivation is not itself economic in nature. This is Justice Scalia's opinion in Raich. And Scalia picked up on this one sentence from the Lopez opinion. Stevens had also been a different way. Okay. All right. So any other questions on the Lopez majority? No? All right, we have a bunch of separate writings, a lot of concurring opinions. Justice Kennedy and O'Connor would often write together. Were concerned that the federal government was trying to take over local functions. And here, Texas had a law about gun-free school zones. And they, in fact, charged the guy with having a gun in a school zone. But they decided to withdraw it to let the feds take over. And that's the exact wrong idea. Actually, the feds should not be leading this. It should be the states with the police power leading these charges. Okay? Justice Clarence Thomas, who we'll talk about quite a bit this class, he is uncomfortable with the bulk of case law from the 19th and 20th century. He would say, temper its Commerce Clause jurisprudence to be more faithful to the original understanding of the Constitution. He said before he would abolish the substantial effects test. He would overturn Wicker tomorrow. And he's been very candid about this. There were several dissents. Justice Breyer's, I always think, is the most compelling. Breyer explains that, in fact, there is a relationship between guns and school zones and interstate commerce. And he says, well, if students are afraid of guns, they may not learn as well. And if they don't learn as well, that has affecting education, and people aren't educated, then they won't get good jobs. And if they don't get good jobs, it injures the economy. There you go. And the majority says that Breyer's approach is piling inference upon inference upon inference. Remember the logic in the 8th grade? If P, then Q. Remember this from high school? Breyer's entire world is piling these sort of inferences. If this happens and this happens, if this happens and this happens, if this happens and this happens. And the court said that's too remote, to use Chief Justice Chase's words, right? That the linkage between Mr. Lopez bringing a gun to a school and interstate commerce is so far apart, the fit is not nearly tight enough that Congress can enact this sort of regime. Okay. All right. Any other questions or any questions on Lopez? Very important case. The reading says that this case sent shockwaves. That's an understatement. Law professors freaked the hell out. Whenever the Supreme Court does even though a slightly conservative thing, law professors lose their minds, right? Like the court can strike down abortion laws in 42 states. All right, whatever. The court can strike down marriage laws in 30 states. Whatever, that's fine. But oh my God, they strike down a statute that already been reenacted. It's like the end of the freaking world. They always overreact. They have no sense of self. It's whatever. Abortion laws in 42 states struck down, no big deal. Supreme Court just killed the death penalty. Okay, that's fine. But my God, the court declared a law and constitution that Congress already reenacted. My God, we have to grab the torches and pitchforks and head to Justice Scalia's house. Slightly exaggerating. But we have here then Lopez. Okay. Any other questions on Lopez? And notice he doesn't use the word necessary and proper anywhere in his opinion, but it is basically the entire discussion of the A, the activities, the CIA. The A part is all necessary and proper. C and I can be just commerce, kind of, but A is basically all necessary and proper.
So when you see people making jokes about the scope of the Commerce Clause, they're really talking about necessary and proper. They are. It's commerce plus necessary and proper. And I'll tell you, most law professors don't actually get this because they just read the opinions. And I think it's a misimpression the court's giving. But whenever you see the word affects, it's necessary and proper, right? It is. It has to be. They have to go back to Marbury. This becomes very clear in the Obamacare case, right? Because what the court holds in the Obamacare case, which I'll give you a preview for tomorrow, is that the mandate to buy insurance might be a necessary means to regulate commerce, but it's not a proper means, right? That case crystallized what Rehnquist was getting at 2 decades earlier. That case crystallizes what Jackson was alluding to, right? The court wasn't overruling the New Deal cases. They were simply explaining when it was no longer proper. That's what South Dakota v. Dole was about. That's what Obamacare was about. Anyway. This part of the class actually makes a lot of sense. We get to the second half of the 14th Amendment, it's whatever. But here there's actually rules I can teach you. There are rules in the other half, but I like the first half a lot better. It's a lot easier to teach for me. Okay, let's do the next case, which is pretty short. Like 2 or 3 pages in your book, I think? Morrison, you love that one, right? It's like a 3-page case. United States against Morrison. This was a very significant case for a lot of reasons.
During, I think it was in 1994, Congress enacted a law called VAWA, Violence Against Women Act, which, contrary to its name, was not only about violence against women. It did a lot of things. It was concerned about gender-motivated violence, which is not just man hurting women, also it's women hurting men. It goes both ways. So for example, if you are an immigrant and your significant other is abusing you, that might give you an opportunity for a special visa, right? There are lots of aspects of VAWA that are in effect today. Indeed, Joe Biden, the former senator from Delaware, was one of the lead sponsors of VAWA. Portions of VAWA were declared unconstitutional by Morrison in 2000, but not all of it. Portions. The facts of Morrison are fairly gruesome. You have, her name was Christy Brzon-Kala. She was a student at Virginia Tech, and she was raped by two football players, varsity football players, D1. These guys are basically, giants on campus. She was raped. The university took no meaningful action. The local police department did not charge them, they did not indict them, they did not go after them for any sort of prosecution. Okay. Brzon-Kala then decides to file a lawsuit. She sues Morrison and one other guy, I forgot his name. Crawford, yeah. Morrison and the other guy was Crawford. And I always like to mention names. I think their names are worth mentioning for the annals of history. They sort of skated by. By the way, neither of these guys made pro. I don't think any of them ever went to NFL. I don't know either of their names. But she sued Morrison and Crawford. Now, suing two former college players who never went pro is basically a waste of money. These guys are judgment proof, right? You can sue them for an assault in court. You're not collecting anything. She also sued the university, Virginia Tech. Virginia Tech is a state university. Now, we discussed in the first day of class the 11th Amendment, which generally means you cannot sue a state, and as has been interpreted. I don't want to get into that quite yet. Christy Brzon-Kala could not have walked into a state court in Virginia and sued the state university. They would have thrown her out saying that the state has sovereign immunity, you cannot sue here. But VAWA provided that if a state government engages in some sort of gender-motivated violence, they can be sued. VAWA waived, or if you want to use the big word, abrogated, A-B-R-O-G-A-T-E-D, abrogated. VAWA said we are going to waive or abrogate a state's sovereign immunity so the state can be sued in federal court. And VAWA also created what's called a cause of action, right? The same way if you go to state court and you sue someone for a battery or a tort, Congress created a federal cause of action that you could sue in federal court for someone engaging in an act of gender-motivated violence, right? Which was the both the rape itself as well as the university's refusal to actually take any action about the rape. Okay, make sense? Everyone with me so far? Again, had Brzon-Kala walked into state court, she would have been dismissed in 5 seconds. You can't sue the state. So she used VAWA to sue in federal court the federal cause of action. The question in Morrison was twofold. One, could Congress waive the state's sovereign immunity? We will come back to that question in about 3 or 4 classes. We'll come back. We actually will do this case again. So we'll do that later. So put aside the first question about the lawsuit. The second question, could Congress even create the federal cause of action for gender-motivated violence? Right? Could Congress create the gender violence cause of action? Right? Could Congress allow a person to be sued in federal court for engaging in gender violence? All right. Now, the first thing to recognize is that VAWA and the Gun-Free School Zone Act were very different. Right? The Gun-Free School Zone Act, the legislatures were lazy. Right? They didn't put any sort of jurisdictional hook. Right? In contrast with VAWA, Congress had hearings. And these hearings developed a record with testimony. And the testimony suggested that violence against women, and really it's not just against women, but it's any sort of violence against gender, but primarily women violence, does have an extensive economic effect nationwide, right? That if a person is abused in a state, and lots of people are being abused in a state, that in the aggregate, those activities will then have a substantial effect in interstate commerce. And therefore, Congress can regulate these local activities of gender-motivated violence. Everyone with me? So what's the problem? Who's Audrey next, I think? What's the problem, Audrey? Why then can Congress not aggregate these local activities that substantially affect interstate commerce? Why can't they aggregate?
I think here, the Rehnquist majority, they said that there wasn't a linkage between the gender-based violence, and it wasn't, kind of like Lopez, it wasn't a non-economic activity.
Bingo, it was non-economic. Rehnquist writes, gender-motivated crimes of violence are not, in any sense of the phrase, economic activity. Right? Gender-motivated violence is not economic activity. Therefore, Wickard is irrelevant. You cannot aggregate non-economic activity, right? If the activity is non-economic, Wickard's irrelevant, according to the rule in Lopez. And the court says that gender-motivated crimes of violence are not economic activity. Possessing a gun, engaging in violence against a woman, those are all local activities that are not economic. Okay, everyone with me? So the holding in Morrison follows very closely from Lopez, but it wasn't a given, right? There was a fear that maybe Lopez was a blip, right? It was a one-off. But here in Morrison, the court reaffirmed that it would hold the line between economic and non-economic activity. They would not go beyond Wickard. Wickard was the outer limit of how far they would go. And in fact, the court here cites NLRB versus Jones and Laughlin Steele, right? That the court will not allow the obliteration of the distinction between what is national and what is local, right? There has to be some line, some principle, some limit, some limiting principle, you might call it. And here the limiting principle that the Morrison court adopts is the difference between economic and non-economic activity. And the court hoped that maybe if they draw this line, it would prevent Congress from going too far to regulate local activity. Okay. All right, and that's Morrison. Questions on Morrison? Huh?
The majority didn't do a clear distinction between non-economic.
Oh Lord, no, they did not. They did not. That
They
comes,
just kinda threw it out
unfortunately, that comes in the next case where things
That's
go south really quick for Randy.
I wanna make sure.
Yeah. They did not give a definition. They were sort of hoping maybe we'll figure it out later. The failure to define economic here led to the next case.
You're an economic major.
No, I was not, but I
You weren't?
no, I took a couple of economics classes. I do not like Webster's Third though. It's a terrible dictionary. Justice Scalia hated it. He refused to cite it. Okay. All right. Any other questions on the United States against Morrison? All right, let's do the last case. This is a case of personal privilege for Randy. He should really be teaching it because he argued it. It was the only case he's argued at the Supreme Court, but it was a fairly significant one. And the facts aren't the usual thing. Now, Randy says publicly he's never used marijuana, neither have I. But he believed in this cause for the purposes of this limited government separation of powers. The facts of the case are fairly, I think they're kind of sad. You have Angel Raish, who had a brain tumor among other illnesses, and really none of the conventional treatments helped her. The only thing that helped her get by with her symptoms was marijuana. It helped her. It also Dan Monson, another plaintiff, had back spasms and other pains, and the marijuana helped her with her symptoms. California in the 1990s approved the use of medicinal marijuana. And let me just tell you guys, anyone could get a medicinal marijuana card back in the day. It wasn't hard, right? Like if you tell your doctor, yeah, I'm feeling a little sad. Okay, here's your card. So basically, it was a ruse, right? The entire medicinal marijuana thing was like whoever wants it gets it. Okay, so now the first question. Under federal law, marijuana is a controlled substance. Okay, Tyler, can Congress mandate that California criminalize marijuana?
No.
Why not?
Same concept as mandate of the legal drinking age.
Perfect answer.
Right.
That's what's called commandeering, right? Congress cannot mandate or commandeer that a state raise its drinking age. Congress cannot mandate that a state criminalize marijuana. Congress cannot mandate that a state enforces marijuana laws, right? What happens if a state has marijuana laws in the books and the sheriff say, you know what, we're not going to enforce these laws, I think they're unjust. The feds can't come in and say, you have to enforce it. Instead, Faven, what did the federal government do? They can't force the states to enforce marijuana laws. What can the feds do? Well, they can maybe bribe the states to enforce it, but more directly, what do the feds usually do if the states aren't going to enforce the law? What can the federal government do if there's drugs in the states and California's not doing anything about it?
Over police,
With?
state or federal?
Send in their own guys.
Yeah.
Send in the feds. Send in Drug Enforcement Agency, right? DEA. Even though Congress cannot force the states to enforce federal law, the federal government has the power to send in their own agents to the states to enforce federal law. And that's exactly what happened with Angel Rach, right? The feds raided their plants in Dan Monson, right? And the feds seized their marijuana. State police wouldn't do it. State police didn't care. Like, we don't care. It's legal under our laws. But the feds came in and they sued. Now, who was Gonzalez? He was the Attorney General. Before that was Ashcroft. And the Attorney General was sued by Rach and Monson for seizing their marijuana. Now, what was the argument that Randy and the others raised? That Congress cannot regulate locally grown, locally cultivated marijuana that was neither bought nor sold. That was the key of the case, right? This was grown locally. The seeds never crossed state lines. The plant never crossed state lines. Everything was local. Moreover, it wasn't bought or sold. That both Rach and Monson were given these drugs free of charge. There was no economic, well, I shouldn't say that. There was no bartering, no buying, no selling going on. So let's just understand this under Lopez and Morrison, right? So Lindsay, under Lopez and Morrison, do you think the mere cultivation of marijuana is an economic activity? Be honest.
Under Lopez and Morrison.
What do you think? Maybe, yeah. Actually, I actually think Randy had a harder case than he does. He thinks this case was easy. No. He actually understood how hard this case was. But let's just read Lopez and Morrison. Is the answer clear whether this is economic activity? No, I don't think it is. And I'll be perfectly candid on this one, right? And I think a response to this is, what about Filburn, right? Filburn was growing wheat that was not going to be sold. Now, some of the wheat would be sold, some wouldn't. But a lot of the wheat he was eating himself. So perhaps under the Filburn definition of economic, this was economic activity, which Congress could then regulate. Yeah, Tyler. I go back and forth on this one. I think about it all the time.
Would this not be the same as trying to, as prosecuting somebody that received wheat from Philip?
Oh, I see what you're saying. That it transferred hands, so that's a different fact pattern.
This is the person in possession, not the wheat brewer, not Filbert.
I think Diane grew her own plants, so I don't think that would work. So Angel, if I remember correctly, she didn't grow her own plants, but Diane grew her own plants. So I think that would work maybe for Angel, but not for Diane.
I don't remember from the case. Does it say how much was it?
This was, I think, it was a small amount for them to consume
6
it.
plants.
Yeah, it wasn't a large amount. But the question is, you only aggregate if it's economic activity, which is the first question, right? You can't aggregate unless it's economic activity.
So that's the first thing we should decide.
So that the issue from Lopez is this activity economic? Okay, that's the big question, right? Is the activity economic? Justice Stevens wrote the majority opinion here, and the vote was 6-3. The vote changed from Lopez. 2 members of the majority flipped sides: Justices Kennedy and Justice Scalia. Right, Kennedy and Scalia were both in the majority in Lopez and Morrison. Kennedy and Scalia then joined the majority in Raich. This case is often called the drug war exception to federalism, right? That Scalia and Kennedy were so concerned about this drug market that they were willing to sacrifice their principles. I don't know about that for Scalia, maybe for Kennedy, I'm not sure. I think Scalia had a very important concurring opinion for different reasons. But Justice Stevens was in the majority, and he gave himself the majority opinion. By the way, the way it works is, who gets to decide who writes the majority? The most senior judge in the majority gets to assign the authorship. So here, the Chief Justice was in dissent, and Stevens was the most senior justice. He was appointed in 76, I'm sorry. 74, 76, I'm blanking. It was a Ford appointee. I think it was 74. But Stevens assigned himself the majority. And Stevens says, okay, Morrison did define economic. Lopez did not define economic, so I will. And he gets a definition from Webster's Third Dictionary. And the definition, it drives Randy batty, but it's broad. Economic is the production, distribution, and consumption of commodities. Right? Raich and Monson were creating the drugs. They were consuming them. So therefore, it's economic activity. And once you have economic activity, then you aggregate. And even if 6 plants doesn't have any sort of effect, if all these little stoners in California did this, then they would have a substantial effect. Oh, I said that loud, didn't I? Okay. It's okay. Randy always says that he's never tried marijuana. It gives him more credibility to actually argue this case, which I think is true. Right? A lot of the people who like this case, like, yeah, go pot, and it's like, oh no, we don't like federalism, but they sort of like the pot part. So that was Stevens' opinion, right? And he gave a very broad definition of economic. And once you have a broad definition of economic, at that point, everything is economic. In other words, if you take seriously this definition, the production, distribution, and consumption of commodities, everything's economic. I would even argue that having a gun in a school zone is economic. Having a gun is kind of like consumption, using it, right? Is gender-motivated violence economic? Maybe. I don't know if you use something as part of the violence, use a condom. I don't know. I mean, I'm being somewhat facetious, but if you actually take seriously Stevens' definition, then Lopez and Morrison probably were wrongly decided. Maybe not. I don't know. But Stevens doesn't overrule Lopez and Morrison. He probably wanted to, but he didn't have the votes to do that. He didn't overrule Morrison and Lopez. But Stevens simply gave such a broad definition of economic that you have an on-ramp to aggregation. Now you can virtually aggregate any local activity. Aggregate away once you get there. looking at the Stevens opinion, it's not hard to understand. He's very candid. He thinks Lopez was wrong. He can't overrule it, but instead he gives a very broad definition of economic. So now you can basically aggregate any kind of activity. And notice what I said. You can regulate any kind of activity. What about if Congress is not regulating activity, but instead they're regulating inactivity? A person who's not engaging in activity. That is, Congress is telling you to engage in activity. This was the Obamacare case, right? This was the Barnett argument in the Obamacare litigation. Okay, you SOB, you said economic activity. Ha! This is non-economic activity. Take that, sucker. And the court accepted it. All right? That's for tomorrow. But the fact that Stevens put so much weight on economic means now you shift to, well, if it's not activity at all. And that was the Roberts decision in the Obamacare case. I realize every time I pull this thing, it pulls my tie down a little bit. It's getting very frustrating, actually, to remember not to tug on the thing so much. The reason why I have this mic is when I leave the camera, the audio gets crapped and we walk away, so the mic on my tie makes it much better for class. Okay, so any questions in the Stevens majority?
So if he didn't overrule Lopez and Morrison,
Right.
You cite that as good law?
Sure, they're good law.
Okay.
To be precise, he simply expanded upon Lopez and Morrison. Lopez and Morrison said you could regulate economic activity. He defined what economic meant. I mean, Lindsay asked me this question a few minutes ago. Lopez and Morrison doesn't really define economic. Stevens gave a definition based on Webster's Third Dictionary. Right, a dictionary written, I think, in the 1960s to define a word that's not even in the Constitution. Right, in other words, Rehnquist got cute. He said, aha, only economic activity. I'm so smart, right? And Stevens said, aha, one up on you. Give a broad definition. And by this point, Rehnquist was very sick. He would die shortly thereafter. He wasn't even present at the arguments. Yeah.
I'm curious. Did they have any discussion if they're using the Webster's definition about whether or not it's a commodity? I mean, if there's no buying, selling, trading, index, bartering, transfer, cross anything, I would say no.
Well, they're using the word commodity broadly. It could be anything. Because again, the marijuana was grown by Dan herself. She wasn't buying or selling it. And if something that you grow in your backyard is a commodity, then anything is a commodity. For certain, the gun that Lopez had was a commodity. He bought it, or maybe he stole it. I actually don't know. But he got it somewhere. Yeah, in the video, I actually have a picture of him. Someone years ago sent me his high school yearbook, a photo, but it was this blurry cell phone photo. It was a picture of Lopez playing soccer in the high school yearbook in San Antonio. So any questions in the Stevens opinion? All right, I think you're next, Tyler. Okay. I can never keep track with this small class. Let's go on to Scalia. Scalia's opinion, I think, is probably the most important of the entire lot. He did not join the majority opinion, right? He did not accept the economic definition of Webster's dictionary. For him, that'd be like the worst thing in the world. He only concurred with the court's judgment. Walk me through, Tyler, Scalia's opinion. It's very nuanced, and most people to this day still don't understand what Scalia was getting at. They're so eager to call him a hypocrite, they don't realize what he was actually doing here.
Well, it seems that his point was that the Commerce Clause was the wrong basis.
Mm-hmm.
Substantial, I mean, kind of like what Justice Thomas had previously said, substantial effects test. In this case, Scalia agreed that that's not applicable in terms of this interstate commerce, unless it's a local activity interfering with a national initiative. But his choice of authority was necessary and proper clause, if anything.
Okay, very good. All right, so Fabian, let me ask you this question. Does Congress have the power to prohibit the shipment of drugs across state lines?
Yes.
Okay, they do. Okay. If people can grow marijuana locally, like local pot, right? If they can grow marijuana locally, does that hinder the federal government's ability to police the interstate drug trade?
Well, if it's going, no.
Well, think about it. if I can buy locally grown pot, what am I not going to do?
Goes across state lines to buy it.
Very good, very good. So the argument is this. Undoubtedly, Congress can try to prohibit interstate shipment of drugs. But what happens when local sales frustrates that national goal? Scalia says, then Congress can regulate that local activity. Right? Scalia says, Congress could reasonably conclude that its objective of prohibiting local marijuana from the interstate market could be undercut if those activities were legal. Right? If it was legal to grow local marijuana, then Congress can't ban local marijuana from the interstate market. In other words, Congress wants to stop marijuana from leaving California. But if all these people are growing pot, some of it is going to leave the state. And Congress's goals are then frustrated. So in other words, the ban on local marijuana is essential, that's the key word, essential to a broader regulatory scheme. It's essential to a broader regulatory scheme.
But and Champion's still good law at this time, right?
Yeah.
How does that reconcile with Champion?
What's the problem?
I mean, they said that they can still sell lottery tickets within the state. It's the transport across state lines that was the problem. Could this not be the
Well, I think it's a different issue, right? This statute is not banning the local. It's not banning the transportation. It's only banning the cultivation or possession. Right? Champion's not really relevant.
Which they said, well, I was thinking, I mean, it's based on, it was a moral issue. So
Right.
They could have, they were.
But the lottery tickets were Paraguayan, right? They actually traveled overseas.
Right.
Here, all the marijuana never left her backyard. It was all local in California. What Scalia is saying, though, is that if this local growing can undercut the national marketplace, then Congress can ban the local growing. Scalia doesn't say this is economic activity. He doesn't say that it's economic or non-economic. He doesn't say substantial effects. What he says is Congress has the necessary and proper power to ban this. Why? In order to successfully ban drug trade over state lines, it's both necessary and proper to ban this local growth. Let's say that one more time. To prevent this weed from leaving California, it's both necessary and proper to ban the local cultivation of marijuana. Right? Everyone with me so far? And so the key question is this local activity necessary to a broader regulatory scheme? If it is, then Congress can do it. Right? Scalia explains this is both a necessary and proper. Without question, this intrudes upon the states, right? California wants its people to have marijuana. Feds say, no, you can't. But Scalia says it's both necessary and proper. Here, the court's deferential, right? Scalia didn't say that Congress actually had this intent. He says they could have had this intent. Congress could reasonably conclude, right? This is what we call rational basis style review. Maybe Congress had this intent, maybe it didn't. So here Scalia is being deferential. He's not going to second guess them. So this is not the aggregation principle. It's what can be based on a larger federal regulatory scheme.
Kind of like Wickard,
Yeah.
how they were saying that the weed, people were buying the market.
Well, but it's a little different, right? Scalia is not using the substantial effects test, but looks a lot like it. It looks a lot like it. It's basically Wickard in name only, right? It looks a lot like it, but I think the difference is it's not based on a bastardized reading of the Commerce Clause. It's based solely on the Necessary and Proper Clause. It's more overt. But the effect is very similar to Wickard. In other words, if Congress enacts the Agricultural Adjustment Act regarding the growing of wheat, that's a broad federal regulatory scheme. And if one local farmer grows his own wheat, that undercuts the federal scheme. Therefore, under Scalia's framework, it can be banned.
Mm-hmm.
So the effect is very similar to Wickard, very similar. But it's a little bit more candid on what it's being based on. It's not Commerce Clause, it's necessary and proper. The argument then becomes if Congress does not have a federal regulatory scheme, then they can't regulate it. Of course, Congress always does. But again, this is still premised on activity. We'll see in the Obamacare case next time what happens when we're dealing with inactivity. All right, so any questions on the Scalia opinion? Right on time, okay. I think Lindsay, you're next. O'Connor dissented in Raich. She was also in the majority in Lopez. What's O'Connor's concern?
O'Connor rejected the broad definition of economic activity and stated that that would sweep all activities into the reach of Congress.
Yeah.
And it would blur the line of what is national and what is local, and that there would be, if they went this way, there would be little left to the notion of the enumerated.
Yeah, it would basically obliterate the difference between the state and the federal governments, right? It would obliterate it. And this has been the fear all along, that if you have a too broad definition of what Congress can regulate, there are no limiting principles. And O'Connor is not happy with this. Chief Justice Rehnquist dissented. He joined O'Connor's dissent. But at this point, he was quite ill. This was in 2005. He would actually die, I think, in, September of 2005. So he died a few months later. And in fact, he wasn't even present at the oral argument. If you look at the little graphic in the video, Stevens is sitting in the center chair. Rehnquist was too sick to attend. He would participate by phone, which is not ideal. But he joined Rehnquist's opinion. September 2005. He died 3 months later. Once again, Justice Thomas dissented. He would abandon the substantial effects test altogether. Again, he's the only justice for that position, but he's very vocal about this. All right. So any question on the dissents in Raich? All right, so where are we then, right? We've gone up and down so many times. At this point, Raich, at least as of 2005, was the broadest expansion of federal power the court recognized. That so long as something involved the production of commodities or the consumption of commodities, that's an economic activity. And because it's an economic activity, you can aggregate those and figure out whether in the aggregate there's a substantial effect in interstate commerce. The Rehnquist court tried to put a limit on the growth of federal power after the New Deal, and the economic versus non-economic activity line was an effort to do that. It didn't hold because Justice Stevens got to define what economic is. The next case, which we'll do in class all day tomorrow, is 2012 NFAB versus Sebelius, where the court recognized another line. It's not economic, non-economic, but activity versus inactivity. And the court, at least to this day, has not retreated from that line. They haven't really gotten much further than it either. Okay. Any questions on Raich, on Lopez, on Morrison, on Dole? No? All right, have a good night. I'll see you tomorrow.